Hello, my name is Sophie Crampton, and I'm a family law barrister at Fulbright Court. Welcome to this webinar, Unaccompanied Asylum-Seeking Children, A Family Law Perspective. This webinar will last 30 minutes and will discuss the 1996 Hague Convention, Articles 36 and 37 of the Vienna Convention on Consular Relations, and 5 key bits of case law. Firstly, what do we mean by unaccompanied asylum-seeking children? As some of you may know, when we talk about unaccompanied asylum-seeking children, we are talking about children who arrive in the UK without anyone who can exercise parental responsibility for them. The majority of these children will arrive alone, though some may travel with or be met on their arrival by someone claiming to be a family member. Even in cases where the child is ultimately placed with that family member, a lot of what we discuss in this webinar will apply, as the person will not have parental responsibility for the child and therefore care proceedings will be required. In terms of the areas covered by this webinar, the webinar assumes prior knowledge of care proceedings but does not assume any prior knowledge in relation to unaccompanied asylum-seeking children. This webinar aims to help you identify and address the challenges that can arise in these cases, focusing on questions of jurisdiction, notifying other countries, threshold, the location and assessment of the child's family, as well as the child's immigration status. Turning first then to jurisdiction. The first question to ask yourself in relation to these cases is, in the post-Brexit era, does the court have jurisdiction to make decisions about the child? The short answer is yes, for all care proceedings issued after 11 p.m. on the 31st of December 2020, i.e. after the UK officially left the European Union. The 1996 Hague Convention must be applied when considering whether the court has jurisdiction over a child. The UK is a signatory to the Hague Convention, and signatories are referred to within the Convention as contracting states. Countries that have not signed up to the Convention are referred to as non-contracting states. We will start by looking at Article 5.1 of the 1996 Hague Convention. Article 5.1 states the judicial or administrative authorities of the contracting states, of the habitual residence of the child, have jurisdiction to take measures directed to the protection of the child's person or property. In other words, if the child has acquired habitual residence in the UK courts will have jurisdiction. If the child has habitual residence in another country, the UK courts may or may not have jurisdiction, as we will discuss during this webinar. There have been 2 recent cases on the application of Article 5.1 to care proceedings. Neither of these cases involve asylum-seeking children, but they contain important principles that can be applied to asylum-seeking children cases.